The certified letter arrived on a Tuesday, but its impact would shake my world for months. Inside that envelope wasn't just a violation notice. It was a declaration of war against my family's future and my belief in doing what's right. And they had no idea who they were messing with. Have you ever received a letter that made your blood boil? One that questioned your right to make improvements to your own property? I'd love to hear about your experiences with HOA overreach in the comments below, because I have a feeling my story might resonate with more than a few of you. My name is Mark, and my wife Sarah and I moved to Meadowbrook Heights 5 years ago. We fell in love with the community, the palm-lined streets, the immaculate common areas, the sense of pride residents took in their homes. What we didn't anticipate was how that pride would transform into control. Meadowbrook Heights is the kind of Arizona subdivision where every blade of grass seems to be measured for uniform height. The HOA board, led by President Brenda Thompson, a retiree with apparently nothing better to do than patrol the neighborhood with a clipboard, takes their architectural control very seriously. When Sarah and I decided to install solar panels last year, we did our homework. Arizona has some of the best solar access laws in the country, explicitly protecting homeowners' rights to install solar energy systems. We even hired a professional installer who specialized in HOA-friendly installations, placing the panels on the rear-facing slope of our tile roof where they were barely visible from the street. The installation cost us $18,000, every penny. We'd saved for 2 years, but with Arizona's scorching summers sending our electric bills into the stratosphere and our commitment to reducing our carbon footprint, it felt like the right investment. The first few months were glorious. Watching our electric meter spin backward was satisfying in a way I can't fully describe. We were generating clean energy, saving money, and feeling good about our contribution to the environment. Then came the letter. Violation notice. Unauthorized installation of solar panels, it read in bold letters. Per Meadowbrook Heights CC&R. Section 7.4. All exterior modifications require prior architectural committee approval. Your installation of solar panels without said approval constitutes a violation. You have 30 days to remove the panels or face fines of $50 per day, plus legal action. I laughed when I first read it. This had to be a mistake. We'd followed all the state laws, and our installer had assured us the panel's minimal visibility wouldn't be an issue. I called the HOA management company and spoke with Linda, the community manager. I'm calling about the violation notice regarding our solar panels, I said, trying to keep my voice even. There must be some misunderstanding. Arizona law explicitly protects homeowners' rights to install solar panels. Mr. Henderson, Linda, replied in a practiced monotone, while state law does protect your right to install solar panels, it doesn't exempt you from following proper architectural review procedures. The board is concerned about the visual impact on the community. The panels are on the back of our house. You can barely see them from the street. The architectural committee maintains that the panels are visible from certain angles and therefore require approval, which was not sought or granted. I requested a hearing with the board, figuring once I explained the situation and showed them the state laws protecting our installation, they'd drop the issue. How naive I was. The hearing was set for 2 weeks later. Sarah and I arrived with a folder full of documentation. Arizona Revised Statutes, Title 33, Chapter 4, Article 8, the Solar Rights Act, our installation permits, and even a visibility assessment from our installer showing minimal street visibility. The board meeting room was sterile and intimidating, a long table with Brenda Thompson at the center, flanked by 4 other board members. Residents weren't allowed to speak unless called upon, and even then, only for 3 minutes. When my turn came, I laid out our case calmly and professionally. As you can see from these documents, I explained, Arizona law not only permits but encourages solar installations. Our panels are minimally visible and represent a significant investment in both our home's value and environmental sustainability. Brenda adjusted her glasses and stared at me coldly. Mr. Henderson, we appreciate your presentation. However, the issue isn't whether solar panels are permitted in Arizona. It's that you failed to follow proper procedure. The Architectural Committee exists to maintain the aesthetic integrity of our community. Your installation, regardless of its environmental benefits, violates that integrity. I was stunned. But the law specifically states that HOAs cannot unreasonably restrict solar installations. And we're not restricting them, Brenda countered smoothly. We're simply requiring that they go through proper approval channels to ensure they meet community standards. Since you didn't do that, you're in violation. The meeting ended with a directive. Remove the panels within 30 days, or begin accruing daily fines. As we walked out, Sarah took my hand. What do we do now? We fight, I said, though I had no idea how yet. That night, I researched everything I could find about Arizona solar rights and HOA law. What I discovered was both encouraging and frustrating. While Arizona had strong solar access laws, there were loopholes that HOAs could exploit, particularly around the approval process. I contacted a lawyer specializing in HOA disputes. David was recommended by a co-worker who'd faced a similar battle over a patio cover. Mark, I've seen this pattern before, David explained over coffee. HOAs know they can't outright ban solar panels, so they make the approval process so difficult that people give up. They're counting on you to either remove the panels or spend more fighting them than the installation is worth. But that can't be legal, I protested. It's a gray area. Technically, they can require architectural review. What they can't do is unreasonably deny approval once you've applied. The problem is, you didn't apply before installation, because our installer said they weren't necessary, given the visibility and state laws. David nodded sympathetically, and he might be right, but the HOA is using procedural technicalities against you. We have 2 options. Fight this legally, which could take years and cost tens of thousands, or try a different approach. What approach? Apply for retroactive approval, document everything, and if they deny it, we might have a stronger case for harassment and selective enforcement. It seemed like a long shot, but it was better than nothing. We filled out the architectural modification application, including detailed photos showing the minimal street visibility of our panels, and paid the $250 application fee. 3 weeks later, we received our response, denied. The reason? Solar panels do not conform to the Mediterranean architectural theme of Meadowbrook Heights and create an inconsistent appearance within the community. I was furious. How could solar panels violate an architectural theme when they were barely visible? We requested another hearing, and this time David came with us. The board was clearly annoyed to see a lawyer present. Brenda's smile tightened as David introduced himself. We're here to request reconsideration of the architectural modification application for the solar panels. David began calmly. As you know, Arizona law prohibits HOAs from unreasonably restricting solar installations. Denying approval based on vague architectural concerns without specific evidence of negative impact could be considered unreasonable. Brenda bristled. We're not being unreasonable. We're maintaining community standards. The panels are visible from the street and don't match the aesthetic of the neighborhood. With all due respect, David countered, the panels are on the rear slope of the roof and are only visible from a few specific angles. Furthermore, Arizona courts have consistently ruled that minimal visibility is not sufficient grounds for denial of solar installations under the Solar Rights Act. The discussion went back and forth for nearly an hour, with David citing case law and Brenda sticking to her guns about community aesthetics. Finally, one of the other board members, a man named Robert, who had been quiet most of the meeting, spoke up. What if we compromise? The Hendersons could install a screening element to further minimize visibility, some kind of architectural feature that would block the panels from street view. Brenda looked irritated at the suggestion, but couldn't outright reject it without appearing unreasonable. I suppose that's a possibility, she conceded. The Hendersons would need to submit plans for the screening element, and it would need to be approved before the solar violation would be considered resolved. It wasn't a victory, but it wasn't a complete loss either. We had a path forward, or so we thought. We hired a landscape architect to design a decorative trellis with climbing vines that would screen the minimal visibility of the panels from the street. The plans were submitted, and after another $150 application fee and a month of waiting, they were approved. Construction on the trellis began immediately. It cost us an additional $200, but at least it would resolve the issue, or so we thought. The day after the trellis was completed, we received another certified letter, violation notice. Unauthorized installation of trellis structure per Meadowbrook Heights, CC&R Section 7.4. All exterior modifications require prior architectural committee approval. Your installation of a trellis without said approval constitutes a violation. You have 30 days to remove the trellis or face fines of $50 per day, plus legal action. I couldn't believe it. They had approved the trellis plans themselves. Now they were claiming we never had permission. I called Linda at the HOA management company again. Linda, this is Mark Henderson. We just received a violation notice for the trellis that the board approved. What's going on? Mr. Henderson, the board approved the design plans, but installation requires a separate permit and inspection process, which you did not complete. No one mentioned a separate permit. We were told that once the design was approved, we could proceed with installation. I'm sorry, but that's the process. You'll need to remove the trellis and start over with the proper permits. This was clearly harassment. They were moving the goalposts and adding requirements that had never been mentioned before. I called David, who was equally outraged. This is classic HOA harassment, he said. They're creating impossible standards and then fining you when you inevitably fail to meet them. We need to document everything and consider legal action. Meanwhile, the fines were accumulating, $50 per day for both the solar panel violation and the new trellis violation. That's $100 per day, $3,000 per month, with no end in sight. Things were getting serious, and I want to pause here and ask you, have you ever been in a situation where it feels like the system is stacked against you, where no matter what you do, you can't win? Let me know in the comments. We decided to hold a neighborhood meeting to explain our situation. I printed flyers and distributed them to nearby homes, inviting residents to come hear about our battle with the HOA over solar panels. To my surprise, about 20 people showed up, including Robert from the HOA board. I explained everything that had happened: the solar installation, the initial violation, the denial of our application, the compromise with the trellis, and now this new violation. When I finished, Robert stood up. "I want to apologize," he said. "I wasn't aware that the management company was handling the Hendersons' case this way. This isn't how our board intended to operate." Another neighbor, Maria, spoke up. My husband and I have been considering solar panels too. If this is how the HOA treats people who try to install them, that's a problem." The meeting ended with a petition circulating to demand a special meeting of the full HOA membership to discuss the solar panel policy. We gathered signatures from over 25% of the homeowners, more than enough to require the board to call a special meeting under the bylaws. The meeting was set for a month later. In the meantime, the fines continued to accumulate. David suggested we file a formal complaint with the Arizona Department of Real Estate, which oversees HOAs in the state. We did, documenting every interaction, every violation notice, every fine. We also reached out to local media. A reporter from the Arizona Republic was interested in our story, particularly given the state's strong solar rights laws. When the special meeting finally arrived, the community room was packed. Nearly every homeowner in Meadowbrook Heights was there, along with the reporter from the Republic. Brenda looked uncomfortable as she called the meeting to order. "The purpose of this meeting," she began, "is to discuss the Hendersons' violation regarding solar panels and the associated fines." Robert stood up. "I move that we first address whether the HOA's actions regarding the Henderson solar panels comply with Arizona law and our own bylaws." The motion was seconded and passed. David then presented our case, methodically documenting every step of the process and how the HOA had violated both state law and their own procedures. When he finished, I stood to speak. "Sarah and I moved to Meadowbrook Heights because we loved the community. We invested in solar panels, not just to save money, but because we believe in reducing our environmental impact. We followed what we believed were the correct procedures based on state law and guidance from our installer. Instead of working with us, the HOA has fined us thousands of dollars, forced us to spend additional money on a trellis they then claimed we didn't have permission to install, and created an atmosphere of hostility toward renewable energy in our community." I paused, looking around the room. "This isn't just about solar panels. It's about whether this HOA exists to serve the homeowners or to control them. It's about whether we're moving forward as a community or clinging to outdated rules that don't serve us anymore." When I finished, the room erupted in applause. Even some of the board members looked moved. Then Maria stood up. "I've done some research," she said. "At least 3 other homeowners in Meadowbrook Heights have solar panels that were installed before the current board took over. Why haven't they been cited for violations?" Brenda looked flustered. "Those installations were approved by previous boards." "But they don't look any different from the Hendersons' installation," Maria pressed. "In fact, some are more visible from the street. This looks like selective enforcement." The discussion continued for nearly 2 hours, with homeowner after homeowner expressing support for our right to have solar panels and frustration with the HOA's handling of the situation. Finally, Robert made a motion. I move that we immediately drop all violations against the Hendersons, refund all fines paid, and create a new architectural guideline specifically for solar installations that complies with Arizona law and provides a clear, reasonable approval process. The motion was seconded and passed unanimously, except for Brenda, who abstained. We had won. Or so we thought. The next day we received another certified letter. This one wasn't from the HOA. It was from Brenda. Thompson personally, it was a lawsuit. Brenda was suing us individually for defamation of character and intentional infliction of emotional distress related to the special meeting. I couldn't believe it. Not only was she not accepting the board's decision, but she was personally attacking us with a frivolous lawsuit. David was furious. This is outrageous. She's using her position to harass you personally because she didn't get her way at the meeting. We're not just dealing with an overzealous HOA anymore. We're dealing with a board president who's abusing her power. We had no choice but to respond to the lawsuit, which meant hiring a litigation lawyer on top of David's fees. The legal costs were mounting, and the stress was taking a toll on both Sarah and me. But then something unexpected happened. The story about our situation, including Brenda's personal lawsuit against us, was picked up by the Arizona Republic, and then by statewide news outlets, and finally by national renewable energy publications. The public reaction was overwhelmingly in our favor. People were outraged that an HOA board president would sue homeowners simply for defending their right to install solar panels. A renewable energy advocacy group reached out and offered to help with our legal expenses. A local law firm specializing in renewable energy issues agreed to take our case pro bono, and then the Arizona Attorney General's office got involved. They opened an investigation into the Meadowbrook Heights HOA for potential violations of the state's solar rights laws and consumer protection statutes. The pressure was mounting on Brenda and the HOA board. They were receiving calls from media outlets, inquiries from state investigators, and complaints from homeowners who were embarrassed by the negative attention. 3 weeks after Brenda filed her personal lawsuit against us, she suddenly dropped it. No explanation, just a notice of dismissal filed with the court. A week later, she resigned as HOA president, citing personal reasons. The new board president, Robert, called us personally to apologize. Mark, Sarah, I want to express my sincere apologies for everything you've been through, he said. The board has voted to not only drop all violations and refund your fines, but we'd also like to offer a settlement for your legal expenses and the trouble we've caused you. What kind of settlement? I asked cautiously. We're prepared to offer $50,000 to cover your legal fees, the cost of the trellis, and compensation for the stress and inconvenience you've endured. In return, we ask that you sign a standard settlement agreement releasing the HOA from further liability. I was stunned. $50,000 was more than we had spent on legal fees and the trellis combined. It was a generous offer, one that would more than cover our initial investment in the solar panels. I discussed it with David and our litigation lawyer. They both agreed it was a fair offer, especially given that pursuing further legal action would mean more time, stress, and uncertainty. We accepted the settlement. The final settlement meeting was anticlimactic. We signed the papers, received a cashier's check for $50,000, and that was it. No fanfare, no admission of wrongdoing by the HOA, just business as usual. But something had changed in Meadowbrook Heights. The new board, led by Robert, worked with David and renewable energy experts to create a clear, reasonable solar installation policy that complied with Arizona law and respected homeowners' rights. Within 6 months, 3 more homes in Meadowbrook Heights had solar panels installed, all with proper approval and no issues. As for Sarah and me, we still have our solar panels, still generating clean energy and saving money on our electric bills. The trellis, with its climbing vines, provides a lovely green backdrop to our backyard, and we've even added a small vegetable garden beneath it. The $50,000 settlement went into our daughter's college fund, a silver lining to an incredibly stressful chapter in our lives. Sometimes, on a clear Arizona morning, I'll stand in my backyard and watch the sunlight glint off our solar panels. They're not just an investment in our home anymore. They're a symbol of standing up for what's right, of not backing down when someone tries to control what you do on your own property. I wonder if Brenda ever drives by our house and sees those panels. I wonder if she regrets the lawsuit, the resignation, the public embarrassment. I wonder if she understands that she wasn't just fighting against solar panels. She was fighting against progress, against homeowners' rights, against the future. Probably not. People like Brenda rarely see themselves as the villains in someone else's story, but we know the truth, and every time our electric bill arrives with a credit instead of a balance due, we're reminded that sometimes standing up for what's right is worth all the trouble in the world. Have you ever had to stand up to an HOA or other authority figure? What was your experience like? Share your stories in the comments below. I'd love to hear from you. And if you found this story interesting, please consider subscribing for more content about homeowners' rights, renewable energy, and standing up for what's right.